Well, if you're just tuning in, don't fret. Facebook still has all these videos uploaded on Facebook underneath my channel, so you guys can view them on Facebook as well for those viewing on TikTok. Simulcasting here via TikTok and Facebook simultaneously. And if you've been with me for the last few evenings, we've been ripping apart the facade of these foreign actors and showing you guys how to hold them accountable through the House Judicial Committee Review Board, through the Congress and the House of Representatives and the Senate. And so you can go back and watch those videos as well. There's also on Facebook is a document that I have that you'll have to put together, but the rough draft is there, and then you'll have to plug and play your information. But it's time that we hold these actors accountable for what they're doing. And I've been at this for about 15 years, and with the help of the Heavenly Father, I've had a tremendous amount of success. And of course, all the glory go to the Heavenly Father on that. There's been a lot of people that have never scheduled a call with me, never spoke with me a day in their life. And just watching these videos and listening to the literature that I read through have found success in the courts. So we commend those people, because it takes a lot of heart to do this, to go at something that you're not familiar with, to blindly trust somebody you've never met in your life that's bringing you forward information, and to not only take heed in what is being taught and what is being shown to you, but to go research it yourself and then make your own analysis on the information and put it together and put it to use. It takes tremendous courage. I mean, we're talking about people that are risking losing their homes, don't have anywhere to go. They've paid 50, 60 grand, 80 grand to an attorney. The attorney's saying the outcome isn't looking good, and they fire their attorney and decide to gain this acquired knowledge freely given and put it to use and prevail. And it takes guts, tenacity, and a whole lot of heart to be able to do something like that. So for you ladies and gentlemen out there that have taken this information and prevailed with it on your own, absent consultation or anything else, I commend you. That's absolutely brilliant. And you, in yourself persevering, you inadvertently, whether you know it or not, have helped the rest of your brothers and sisters prevail. And so we encourage you guys to tell your stories of what you did, how you did it, and help others out as well. I know a lot of people don't come forward because they fear retaliation. I understand it. I comprehend that. If you're one of those individuals, I will say this: scared money never makes money. All right, I heard that from an old gambler back in the day. And what it takes for this systemic system to continue to hinder prosperity, life, liberty, the pursuit of happiness, and the enjoyment of property is in fact your silence. So I would encourage you to come forward and tell your trials and tribulations and how you found success. And I hope I can instill in you through my words the courage to stand up, not just for you, but for your family, your community, your country, and the rest of mankind. We need to start leading by example, ladies and gentlemen. And so if you're one of those people that has gone the gauntlet, per se, and went through your trials and tribulations and struggles and heartaches, and on the other side came out a better man or woman and persevered, we'd like to hear from you. We'd like to see your story be told by you, and the experiences that you went through, and how you found your path to success. There's many ways to skin the cat, and what I'm here to do is just show you the short, sure-cut path to exposing what they're really doing. There's no denying what they're doing. They're banking. So the state of court for whatever county or city, whatever, the all caps name, case number. This is a letterogatory. A letterogatory is more like it's a friendly correspondence saying, hey, jackass, I know what's up. And if you want to play a deadly game of Russian roulette, I got 6 in the chamber. But you go first. All right? And that's about as polite as I can fucking put it. Under the Hague Convention, Title 28, subsection 1781, I, your proper name, a living man or woman, whichever you may be. Remember, there's only 2 fucking genders for you people out there that are psychologically fucking fucked and probably belong in a nut house. I mean, back in the day, if somebody would have told me they were fucking 16 different things and considered themselves a fucking penguin, that would have been grounds to send them to a fucking loony bin, but far be it from me to fucking push my view on you. And executor for the all caps estate, and they've created a Sesta K Vi trust. Notice to the court of my letterogatory. This is, proceed if you will, but there are fucking consequences. All right? That's basically what a letterogatory is. It's a polite correspondence saying, hey, jackass, I'm being denied due process of law. You're not providing full disclosure to the nature and cause of this transaction. I know what the fuck you're doing. And if you keep fucking around, either the IRS is going to scoop your happy ass up and throw you in a cage, or we're going to send you to Guantanamo motherfucking Bay. All right? 2 options here. All right? And so this can be sent to the judge in chambers. I like to just go look up their private home address. That really tickles their fancy. And I like to send it directly to them because that's the kind of asshole I am. They like to hide their address. They like to say it's because people might retaliate against them who are criminals. Well, the truth of the matter is, in almost 98% of the cases that go before the courts, there are no criminals. All right? They're doing maritime admiralty jurisdiction, utilizing statutes, codes, city ordinances, rules, and regulations to generate revenue, using the penal code, which have penal bonds attached to them. If you've been with me for the last few days, you should be starting to get the clearer picture. You should be able to start piercing that proverbial veil and pull it back from your eyes and see the system for what it is. All right? Access removed. Well, look at that. TikTok shut her down, boys. That's funny.
The very word church.
Live access suspended. Live November 19th, 2024. That's funny.
The very word church.
All right. It's just me and you, Facebook. TikTok don't like us. Too much truth. So, true name. Wait. We skipped a part. Country, county, court, and demand my name be cleared of this alleged criminal case for the reasons set forth below. I, your true name, have learned that this alleged court that has scheduled a case cause claim against me is not really a court as per the Constitution of the United States of America, not an Article III court, but rather a military tribunal, Article 1, Section 8, that properly belongs in the territorial jurisdiction of Article 1, Section 8, Clause 17, a 10 square mile area, under Admiralty jurisdiction, and is operated as a private for-profit corporation listed on Duns and Bradstreet. Okay, now they have a SAM number as well, sam.gov. 2, I have learned of the fraud that goes on behind the scenes of these alleged criminal cases, which are really civil claims in equity, and the steps taken to securitize these civil claims without giving full disclosure to the people. I am hereby letting the court know that I am opting out of any contract, and I do not allow any documents regarding me or my Sesta K Trust to be securitized and sold to any investors, etc. 3, as you may be fully aware, the fraudulent process is as follows. All cases are civil, though often fraudulently called criminal. The courts are operating under trust law, assuming the defendant is a decedent. civiltor mortis. After finding the alleged defendant guilty, the court clerks sell the judgment to the federal courts through the district courts. Since the defendant is a decedent presumed to be a ward of the court, incompetent, and of unsound mind, the court officials consider themselves as beneficiaries, as the powers that be, international bankers, have concocted a reverse trust scheme on we, the people, who are supposed to be the beneficiaries because we are the actual creditors. 4. When a judge asks if a person understands, he or she is asking if the person is liable for the bond. I am not responsible for the bond of these cases, but I will appoint the judge as trustee fiduciary and be the beneficiary of all proceeds. How are you going to appoint the judge trustee fiduciary? You could do that through the Form 56, ladies and gentlemen. All right, and they should already have a Form 56 on record anyway, and they don't. 5. The judgments are stamped with something to the effect of paid to the order of on the back of and taken to the federal discount window. The judgment now becomes a note. The notes are then pooled together and then become securities, which are yet pooled together and sold as bonds. Said bonds are liens against me, a defendant in error. The United States Attorney's Office has a put code number, QSIP, Committee on Uniform Securities Identification Process, NAIC, publicly traded securities listing definitions. Said NAIC number enables the United States Attorney's Office to trade globally all securities. 9. All U.S. federal courts are registered with the DoD, Department of Defense, where they are registered with the CCR, Contractor Central Registration, under the DoD, which another department called DLIS, Defense Logistics Information Services, which issues a cage code, which means a commercial and government entity, which everything corresponds with their bank account. 10. Said United States Attorney's Office and courts have a DUNS number, Duns and Bradstreet. Also a SAM number as well, which is an alphanumeric number under SAM.gov. 11. Everything filed into a court is securitized without the knowledge or consent of the people or of all parties involved. 12. All criminal cases not heard in an Article 3 court, District Court of the United States, are actually civil. However, the courts again commit fraud, labeling the case as criminal, even for an infraction as minimal as a parking ticket. All cases which are pled out or have a guilty conviction label the civil defendants through unlawful conversion as felons when they are not. This is fraud upon the people at large, and certainly fraud upon the alleged defendants in error. 13. The bank account is at Federal Reserve Bank of New York in New York City. The depository agreement is signed by the clerk of the court. 14. All securities are then deposited with the DTC in New York. 15. An escrow agent is used as a go-between between the clerk's office and the Federal Reserve Bank of New York. 16. 16. The securities end up being listed through the 7th Circuit, Chicago, Illinois, then sent to the DTCC, the clearinghouse, whom lists the securities for trading. 17. All of the lawyers involved are acting as private debt collectors according to the FDCPA, Title 15, 1692. The Bar Association exempts them from having to register as such. However, they operate through call warrants, which are like a put or a call. Doing margin calls is where they convert a case through, similar to a writ of execution, use the case number to buy equity securities. 18. Everything filed into court is securitized and turned into a negotiable instrument, and then turning them into securities. These items are sold commercial items, calling them distressed debts, unifund. The items are then pooled together in what is now called a hedge fund, where they are sold globally. 19. Anytime when there is a risk management involved, it is for the securities. This is an underwriting company. When the hedge funds are going into a global market, they go through Laura Herms, a bondholder and underwriting company and subdivision of Alliance SE of Munich, Germany, PIMCO bonds. 20. After 9 months, all paper is converted to a securities status. This is defined in Title 15, United States Code, subsection 77 AB1, and now considered to be an investment contract. The paper is endorsed to become a security, and the trust is then collapsed. 21. The courts have an account with the IMF, International Monetary Fund, under Interpol. The judges involved and the U.S. attorneys involved do not have an accessible oath of office because they cover up the fact that the oath of office is between them and the IMF. 22. The U.S. judges and U.S. attorneys are actually employees of the IMF and have expatriated out of the United States. They are now unregistered foreign agents under Title 22, 611, Title 22, United States Code 611, 612, and 613, which states all foreign agents must be registered. That's under the Foreign Registration Act of 1938 as amended in 1939. These hypocrites don't even adhere to their own codes. 23. The court judgments are deposited with the IMF. Since this case obviously involves me, I have a drawing to all. I have a special drawing rights to all the proceeds. See UCC 3-305 and UCC 3-306. The court's judgments are monopolized according to Title 16, which is a violation of antitrust laws and also unfair trade practices. 24. Indictments are true bills, meaning they are negotiable instruments. The district's attorney failed to give me a 1099 OID showing me as the recipient of the funds, which is a fraud upon me. In my case, I have not been indicted, but still request a 1099 OID unless the court wishes to close this account. 25. The unlawful funds, through fraud and deception, are deposited in the Federal Reserve Bank of New York, and they have not paid the taxes on this income. According to the IRC, Internal Revenue Code, this is a Title 26 USC subsection 7201 of Title 26 violation, willful failure to file with the intent to evade the tax. 26. A copy of the depository resolution agreement was not made available to me from the clerk of the court. The clerk of the court makes deposits into the Federal Reserve Bank of New York via electronic fund transfers, EFTs. 27. The clerk has a PMIA, private money investment account, which also has a government code. According to the clerk's praxis, the clerk of the U.S. District Court is the registrar in Admiralty. 28. According to the Title 26 USC subsection 6209 of the IRS decoding manual and the ADP Automated Data Processing Manual, all 1099s are Class 5 gift and estate taxes. I am asking for a 1099 OID in this case, as I am not willing to gift you the proceeds. I am hereby asking for the proceeds in their entirety, including interest. 29. It is presumed that by the creation of the birth certificate, my body and the labor therefrom is pledged to the state. This is patently absurd, as this unilateral quasi-contract is lacking in full disclosure to the parents. I have never pledged my rights, nor my body, any labor thereof, nor any creation therefrom, to any gifting program, including any court or court process. 30. I am not a charitable organization. I demand all funds from the case, current and past cases. be sent to me within 30 days, or I will file complaints with the IRS and the SEC explaining the fraud and the theft committed upon me, and issue a 1099 OID. 31. I demand my name and my Cesta K trust name and any derivatives thereof be removed from any and all government databases indicating bad credit, commercial liens, and or the titles of criminal, felon, and or debtor be removed immediately and permanently, non pro tunc. 32. I hereby request or demand a copy of the depository resolution agreement from the clerk of the court and the W-9 from the judge and the U.S. attorney involved, if you wish to proceed with this case. 33. I hereby notice that the court that I am the executor of the Cesta K Vi Trust according to Title 26, U.S.C. subsection 303 and subsection 7701, companies, corporations, and associations and trusts are all decedents. This means my all-caps letter name is a legal estate. My all-caps letter name falls into this class. I direct all of the affairs and financial affairs of the all-caps name and estate. 34. I demand this case account be closed and no further steps taken to securitize it. 35. I hereby ask the court, or demand of this court, as my fiduciary and trustee, to notify local agents and agencies to put me on a do not disturb or detain list so that we do not have to go through this again. Additionally, explain the facts of the case and any violations of the color of law by whom involved. 36. I want to remain confident that the court and its officers want to follow the law and, perhaps, were unaware of the process of civil and criminal cases, and that the public policy enforcers are ignorant of the aforementioned facts regarding their often erroneous administration of the Cesta K Vi Trust. 37. I expect no further harassment from rogue, unregistered foreign agents and public policy enforcers under the color of law. Letter rogatory for relief, the date, time, all that good stuff in your signature. I can't believe I got kicked off of TikTok so quick. That was amazing. That didn't take very long. Was it something I said? I'll be damned. Encouraging people to stand up and sound off like they got a set of fucking balls is threatening to the establishment. Direct response to, all right? So if you've been following me for a while, you understand that what we're going through is we're showing you how the system works and what they're doing, hypothecating your credit into existence, while never providing full disclosure. They'll always tell you the cause of the action. They'll never show you the true nature of it. And the true nature of it is banking, all right? That's why this is so important. All right, so you got the plaintiff, the beneficiary, all that good stuff. Comes now, your name. Move this court for the following. I say demand. Fuck requesting. I'm demanding shit. This request is made pursuant to the provisions of the Freedom of Information Act, Title V, United States Code, subsection 552, and the Privacy Act, Title V, United States Code, subsection 552A, D1, for a full disclosure and release of all records and or data contained in your department and or agency under my name and or identifier to my name. This request sought herein is for bond information and or commercial crime bonding information and or case bonding information and or commercial crimes bonding certificates, Title V, United States Code, subsection 552A2AB, of records that are secured and maintained by your department and or agency. You also have Title 15, United States Code 40 that can be added to this, and UCC 9-210. All right? So write that down. Title 15, USC 40, and UCC 9-210. The records sought specifically, but not limited to, are the compiled files containing criminal case bonding information, 2, criminal bond certification, and 3, bid bond SF24, performance bond SF25, and payment bond SF25A, 25B, SF28, SF34, SF35, SF1414, SF1415, SF1416, SF1418, and OF90 and OF91. Release of lien, release of surety, release of property, okay? Noted criminal case bonding and or the bonds which secured the financing and or the pledge for the financing of the criminal case listed above. 5. Certified true and correct copies of the bonds and identification QSIP, SIC, ISIN, CINS, ANA numbers. 6. Certified indication of the amount secured per bond per each offense charge per 1099 OID report. 7. The expiration date and specified interest for the specified length of time of these bonds. 8. Which governmental body and or whom or what person, i.e. special purchase entities, underwriters, corporations, companies, associations, firms, partnerships, societies, joint stock companies, individuals, and or officers, A, secured the bonds, B, hold the bonds, and 9. Any and all records and data concerning the bonds, thrift financial reports, balance sheets, Federal Reserve Form 2046, 2049, 2099, in accordance with FAS 5 Accounting Standards Codification 450-20, FAS 95, FAS 133, FAS 125, Securitization Accounting, RC-S/RC-B, FFIEC call schedules, AO 10A, the AO 1013, the AO 1015, the AO 430, not otherwise exempt by Title V United States Code subsection 552 A6C B7, Title V USC subsection 552 AJ2 K2, or Law Public Citizens versus Department of Justice 1989, 491 U.S. 440, 105 L period ED 2D 377, 109 CT period 2552, Department of Justice versus Reporters Com 1989, 489 U.S. 749, 103 L period ED 2D 744, 019 S period CT period 1448, Detroit Free Press versus Department of Justice 73 F period 3D 93, 1998, FBI versus Abramson 465 U.S. 615 72 L period ED period 2D 376 102 S period CT period 2054, 1982, including exemptions, Title V United States Code subsection 552B3. If the information, records, and or data requested are placed, filed, secured, and held in a separate, different, and or distinct file by or under another name, number, or identifier other than the case docket number or case identification number, or identifications listed above, I authorize your department and or agency to open and access that file for all the information, records, and or data requested herein. It is further requested that your department and or agency, in response to all the information requested, specifically inform me if and to what governmental body and or to whom and or to what person or persons previously described has been released and or disclosed any of the information and or material requested herein, their name, title, purpose, and need for such information and or material, the date of release, and the specific information and or material released and or disclosed, such information, and the specific reference to authority, statute, or regulation governing such release and or disclosure, Title V United States Code subsection 552B1 through 12 C1 and 4, or the Abraham and Rose PLC versus U.S. 138 F period 3D 1075, 1998, Ray versus Department of Justice 720 F period 2D 1983. Your department and or agency is advised that the bonding and or bonds, info, data, or reports in total are no longer accord exempt status unless under specific exemptions noted, and only with reference to specific citations of authority. Nemps versus Department of Treasury 446 F period Superior Court 102 1987, and Akins versus Federal Election Common 101 F period 3D 731 1996, and Gumko versus Gore 180 F 3D 282 1999, Solar Source Inc. versus U.S. 142 F period 3D 1033 1988 or 98. I agree to pay any reasonable costs or fees applicable to this request and above and or beyond the specified allotments of cost or fees applicable at no charge pursuant to the Uniform Practice Code, the OMB Uniform FOIA Free Schedule and Guidelines, subsection 6B, Fed Regulations 10.017, in compliance with Title 31 United States Code, subsection 9701, or if I am considered indigent, I ask your department and or agency waive all charges pursuant to Title 5 United States Code 552AI3 ETSEQ. Pursuant to Title 5 United States Code subsection 552A6AI, it is noted that your department and or agency has 10 working days following receipt of this request to provide me this information and or material sought. Should any delay occur, it is request that your department and or agency inform me of this delay as provided by Title 5 United States Code subsection 552A6B and the date when your department and or agency will be able to act. In the event that I do not receive the response in specified time provided by statute, I will then be forced to pursue other remedies. Public Citizens versus FTC 869 F period 2D 1541 1989, Blasey versus Tenant 194 F period 3D 90 1999, and GMRI Inc. versus EEOC 149 F period 3D 449 1998. I certify under the penalty of perjury under the laws of the United States of America in the nature of Title 28 United States Code subsection 1746(1) that I have read the foregoing request for information and know the contents thereof, and the information listed above is true, correct, and complete. Request executed this day, this month, this year, respectfully submitted. And then you sign. All right. Now, if you want to get downright nasty, this is what you hit the prosecutor with. And the judge, and the clerk of the court. Hit them all with it. Notice and demand for all criminal bonds, bonding, and other related connected instruments and or documents. I solemnly charge you in the presence of God and of Christ Jesus and of his chosen angels to maintain these principles without bias, doing nothing in the spirit of partiality. 1 Timothy 5:2. All right, so the registered mail number, the receipt on the registered mail number. All right. To the Honorable Administrative Public Servant comes now your name, upper lowercase, the living, breathing man, and hereafter beneficiary to the all caps trust here in the defendant, as obviously in the courts they always do the first name, middle initial, last name. Sometimes they have the period, sometimes they don't. Make sure you pay attention to the details, which this is the constructive trust they created right there. In the above styled and numbered cause, and here presents a special appearance ex parte request for disclosure of all criminal bonds, bonding, and other related connected instruments and or documents, and to support said demand, beneficiary submits the following. Now, I would come in on this one as the surety. Beneficiary doesn't get to make demands, and the beneficiary is entitled to certain disclosures, but the surety really is in the position to make demands. The provision of the Texas Open Records Act, Texas Government Code, subsection 552, the Freedom of Information Act, Title 5, United States Code, subsection 552, in the Privacy Act of Title V, United States Code, subsection 552A, D1, for a full disclosure and release of all records or data contained in your administrative department and or agency or division and or room and or registry and or bank and or financial institution or other depositories that is listed in the name of the defendant, John H. Doe, which this would be your first name, middle initial, last name. Pay attention to the position and the periods and what they do with this, because this is identifying that trust. And realistically, the account numbers are going to be your docket number and your cause of action number, all right? And you want the full exemplified record. You don't want an abstract, which is what they typically give you, is an abstract. You want the exemplified record. And or any variation, derivative, abbreviation, order with or without suffix attached thereto, connected to Social Security Administration number, and you would go ahead and provide that number, and or surrender Texas driver's license number. This guy, in this instance, surrendered his driver's license. That's all good and dandy. This is a bond number. This is also attached to an account. And or cause account number, and these are the series of causes that he's involved in, and or this secondary one, so maybe they charged him up with 3 different charges. I just recently dealt with this in Tennessee with a guy. We did prevail. They charged him up with like 3 different felonies, had him in 3 different venues, and then they charged him up with a bunch of benign motor vehicle code violations. So you had like a total of 5 or 6 different cases going on simultaneously all at once. We combined all these numbers together, and we quashed it because equity will take jurisdiction to avoid a multiplicity of suits. And so thank God for Tennessee's Constitution is a badass Constitution, and for Henry R. Gibson laying down the foundation of equity out there in Tennessee. And or judgment and sentences, warehouse receipt number, see Texas Business and Commerce Code, subsection 7.201 and 7.202, commenced from the county of Harris, room 351. So this would be the suite of the court. See Duns and Bradstreet number. He did his due diligence and went and got the Duns and Bradstreet number for the court. You got to be careful when you go to get that Duns number, ladies and gentlemen, because sometimes they'll say, let's just say in Valley County, the district court, and then other times in the district court of Valley County, and they'll have 2 different Duns numbers. You really got to fucking pay attention. These slick dick motherfuckers are slick. They're slicker than Diddy at a P. Diddy fucking party, all right? They're slick, all right? Mark Ellis, key principal, see attachment number 1. So he attaches the evidence that Mark Ellis is the key principal to this Duns number, which is, in fact, a for-profit private corporation masquerading around as government, negotiating negotiable instruments, utilizing the UCC for profit and gain. They're unregistered securities. Okay, it's identity theft. It's a Hobbs Act violation. It's antitrust violation. It's interference with trade and commerce. It's a whole litany of shit. But again, we don't want to argue. We just want the evidence, because we're going to come take those funds that they're going to take, or that they're attempting to take from you, all while engaging in tax evasion. And how do we prove that? Well, we prove that under Title 26, 6903, when they don't have a delegation of authority, warrant of attorney, power of attorney, letter of assignment, letter of appointment to operate outside Article 1, Section 8, Clause 17, the territorial jurisdiction of the 10 square mile area known as Washington, D.C., the District of Columbia, all right? They have to have the express written consent from the Secretary of Treasury of Puerto Rico to touch the decedent estate. And when they do not have that, your duty is to report them. Somebody said no. The bequest says no. I'm not sure what you're saying no about, son. Jurisdiction is authorized by U.S. Freedom of Information Act, Title V, United States Code, subsection 552 ETSEQ, Title 28, CFR, Code of Federal Regulations, subsection 16.41, request for access to records, and he's using the Texas Open Records request. If you're in another state, you need to go find your state's open record request, okay? And he's using this stuff not to enjoin them in their jurisdiction, but this is the only thing they understand. All right? So when you're communicating with them, you have to kind of learn their bullshit, or they'll say, we don't understand what you're asking for. We don't recognize that. We don't see that. Just think of them as being programmed computers, and you keep trying to get a Pepsi out of a Coke machine, and the Coke machine keeps going, do not recognize, please re-enter, do not recognize, and you keep putting Pepsi in there, Pepsi. It's never going to give you a fucking Pepsi because it doesn't recognize, and nor does it have a code for Pepsi to be able to recognize, all right? So that's the importance of the code. It's not that you're coming into that jurisdiction. You're just simply showing that you understand how their jurisdiction works and what they're bound by, and they are bound by this code, all right? And Code of Federal Regulations, subsection 72.11, which says all crimes are commercial, which means all proceedings are civil in their nature. This demand sought herein is for bond information and commercial criminal bonding information and or case bonding information and or commercial crimes bonding certificates, i.e. appearance bond, liability bonds, General Service Administration, GSA, standard and operational form bonds, and affidavits, and any information, see Title 27, Code of Federal Regulations, CFR 7211, all crimes are commercial, Title 5, United States Code, subsection 552A2AB, of records that are secured and maintained by your department, agency, division, room, registry, bank, financial institution, or on deposit. Records sought specifically include, but are not limited to, the compiled files containing commercial case bonding information, commercial bond certificate, GSA forms, and remember we went through this last night, Standard Form 24 bid bond, Standard Form 25 performance bond, Standard Form 25A payment bond, Standard Form 25B continuation sheet for standard forms 24, 25, and 25A, Standard Form 26 award contract, Standard Form 30 amendment of solicitation, modification of contract, Standard Form 33 solicitation, offer, and award, Standard Form 28 affidavit of individual surety, Standard Form 34 annual bid bond, Standard Form 35 annual performance bond, Standard Form 273 reassurance agreement for a bond statute performance bond, Standard Form 274 reassurance agreement for a bond statute payment bond, Standard Form 275 reassurance agreement in favor of the United States, Standard Form 1414 consent of surety, Standard Form 1415 consent of surety and increase of penalty, Standard Form 1416 payment bond for other than construction contractors, Standard Form 1418 performance bond for other than construction contractors, Standard Form 1440 application for partial payment, Standard Form 1442 solicitation, offer, and award, Standard Form 1443 contractor's request for progress payment, Standard Form 1447 solicitation contract, Standard Form 1448 solicitation contract order for commercial items, Operational Form 90, release of lien on real property, and Operational Form 91, release of personal property from escrow. Noted, criminal case bonding and or bonds which secured financing and or pledge for financing of criminal case number, and the case numbers, of course, as enumerated above. Certified true and correct copies of all bonds and identification of the CRIS, Court Registry Information System, QSIP, Committee on Uniform Securities Identification Procedures, SIC, Standard Industrial Classification System, ISIN, International Securities Identification Number, CINS, CINS, QSIP, International Numbering System, LEI, Legal Entity Identifier, and ANA, Association of National Numbering Agencies. Certified indication, the amount secured per bond per each offense charged per IRS Form 1099 OID report. The expiration date and specified interest for the specified length of time of the bonds. Are they 20 years, 30 years? What's the maturity rate of these bonds? All right, we need to know this. The 1099 OID tells you the scheduled payouts, how much interest occurs before the disbursements of the dividends and derivatives, and the time for which the dividends and derivatives are to be dispersed, which governmental body and or whom or what persons, i.e. special purchase entities, underwriters, corporations, companies, associations, firms, partnerships, societies, joint stock companies, individuals, and or officers, A, secured the bonds, B, hold the bonds, any and all record and data concerning the bonds, thrift financial reports, balance sheets, Federal Reserve Form 2046, Federal Reserve Form 2049, and Federal Reserve Form 2099 in accordance with the FASS Accounting Standards Codification 45020, FAS 95, FAS 133, FAS 125, Securitization Accounting, RC-S/RC8, FFEIC, Call Schedules, AO10A Form, AO213 Form, AO215 Form, and AO430. I love the AO430, by the way. Not otherwise exempt by Title V, United States Code, subsection 552A6C, B7, Title V, USC, and, Title V, USC, subsection 552AJ2, K2, or law, Public Citizens and Department of Justice, 491 U.S. 440, 109, S period, CT period, 2552, 1989, Department of Justice versus Reporters Committee, 489 U.S. 749, 919, S period, CT period, 1448, 1989, Detroit Free Press versus Department of Justice, 73 F period, 3D, 93, 97, 6th Circuit, 1996, FBI versus Abramson, 465 U.S. 615 102 S period CT period 2054 1982, including exemptions, Title V, United States Code, subsection 552B3, all 300,000 plus GME utility.org accounts, LEI. See attachment number 2. All right. So they're running everything through the GME utility, or GMI, what is it, GEMI or GEMI? Anyway, so you want all of this information that your bonds may be tracked through. If the information, records, and or data requested are placed, filed, secured, and or held in separate, different, and or distinct file by or under another name, number, where identifiers other than the cause, case, or docket number and or identification listed above, i.e. such as CRIS, the Court Registry Investment System, all right, which is also known as an auto-trice number as well. So you got the CRIS system with the auto-trice number, etc. I authorize your department, agency, division, room, registry, bank, financial institution, or on deposit to open and or access files. Why is he giving them the authorization to do so? Because everything was built upon him, presuming and assuming they had his consent and that he wouldn't catch on to what they were doing, right? So now that he knows what they're doing, he's putting on notice, hey, shit dicks, you work for me. Congratulations, you just won a prize. You get to either work for me or you go to fucking jail for embezzlement, fraud, peonage, bondage, slavery, involuntary servitude, mixed war against the Constitution, Hobbs Act violation, Clayton Act violation. I mean, the list just goes on. Treaty Against Article 10 violation, violation of 40 Statute at Large, 411 Section 7E, violation of 48 Statute at Large 112. The list just goes on and on and on. Human trafficking, executive order violation, 13818, 13903. That was underneath Trump, by the way. The Biden administration couldn't repeal that executive order. Why? Because it would show their true colors. For all the information, court records, and or data demanded herein. Okay, remember, you have a right to this. Now, I wouldn't be coming in as the beneficiary. I'd be coming in as surety. Because, see, if they don't provide all this, I'm no longer going to insure it. I'm no longer going to allow them to utilize my exemption. I'm going to pull out of this, all right? And I'm going to leave them hanging, holding the fucking bag. It is further demanded that the department, agency, division, room, registry, bank, financial institution, or on deposit in response to all the information demanded specifically inform me if and to the what government body and or to whom and or what persons previously described has been released and or disclosed any of the information or of the materials demanded herein, their name, title, purpose, and need for such information and or material, the date of release, and the specific information and or material released and or disclosed, such information and the specific reference to authority, statute, or regulation governing such release and or disclosures, see Title 5 USC subsection 552AB1 and 12C1 through 4, or law Abraham Rose PLC versus United States F period 3D 1075 6th Circuit 1998 Ray versus Department of Justice 720 F period 2D 216 DC Circuit Court 1983. Your department, agency, division, room, registry, bank, financial institution, or on deposit is advised that the bonding and or bonds, info, data, or reports in total are no longer a court exempt status unless under specific exemptions noted and only with reference to specific citations of authority. Nemtes versus Department of Treasury 446 F period Superior Court 102 in period D period 3 1978. Atkins versus Federal Elections Commission 101 F period 3D 731 DC Circuit 1996, and Gunmoke versus Gore 180 F period 3D 282 DC Circuit Court 1999, and Solar Source Inc. versus United States 142 F period 3D 1033 1039 7th Circuit 1998. I agree to pay any reasonable costs or fees applicable to this request above and beyond the specific specified allotment of the cost or fees applicable at no charge pursuant to the Uniform Practices Code, the OMB Uniform FOIA fee schedule and guidelines, subsection 6B, Federal Regulations 117, in compliance with Title 31 United States Code, subsection 9701, or if I am considered indigent, I ask your department and or agency waive all charges pursuant to Title 5 United States Code subsection 552AI3 ETSEQ. Pursuant to Title 5 USC subsection 552A6AI, it is noted that your department, agency, division, room, registry, bank, financial institution, or on deposit has 10 working days following receipt of this request to provide me with the information and or materials sought. Should any delay occur, it is requested that you inform me of this delay as provided by Title 5 United States Code subsection 552A6B and the date when your department, agency, division, room, registry, bank, financial institution, or on deposit will be able to act. In the event that I do not receive the response in the specified time provided by statute, I will then be forced to pursue other remedies. Public Citizens versus FTC 869 F period 2D 1541 1556 DC Circuit Court 1989. Blasey versus Tenant 194 F period 3D 90 District DC Circuit Court 1999, and GMRI Inc. versus EEOC 149 F period 3D 449 6th Circuit 1998. Declaration. I, your name, by special appearance, certify under the penalty of perjury, pursuant to Title 28 United States Code subsection 1746 1, without the United States, that all statements herewith and attachments hereto are true, correct, complete, and authentic originals and or duplicates of the original. Prayer for relief. Wherefore, premise considered, defendant prays the court provide to the man in haste the following: criminal case bonding information, criminal bond certificate, GSA form, standard form SF24 bid bond, standard form 25 performance bond, standard form 25A payment bond, standard form 25B continuation sheet for standard forms 24, 25, and 25A, standard form 26 award contract, standard form 30 amendment of solicitation modification of contract, standard form 33 solicitation offer and award, standard form 28 affidavit of individual surety bond, standard form 34 annual bid bond, standard form 35 annual performance bond, standard form 273 reassurance agreement for a bond statute performance bond, standard form 274 reassurance agreement for a bond statute payment bond, standard form 275 reassurance agreement in favor of the United States, standard form 1414 consent of surety, standard form 1415 consent of surety and increase of penalty, standard form 1416 payment bond for other than construction contract, standard form 1418 performance bond for other than construction contract. Standard Form 1440, application for partial payment. Standard Form 1442, solicitation, offer, and award. Standard Form 1443, contractor's request for progress payment. Standard Form 1447, solicitation contract. Standard Form 1448, solicitation contract order for commercial items. Optional Form 90, release of lien on real property. Optional Form 91, release of personal property from escrow. Some of the other forms that I would request would also be their 990 form, their W-9, their EIN, their tax identification number, okay? I would ask for their, I got a whole list of forms. I'll bring them up. I demand their Form 56, their 1099-R, 1099-F, 1099 miscellaneous. What else would I ask for? See, I like the IRS because they actually get shit done. All right. I'll get back to you with the rest of the list that I would add to this. Noted criminal case bonding and or bond or the bonds which secured financing and or pledge for financing of criminal case numbers. All right. As styled above, certified true and correct copies of all bonds and identification of the Court Registry Investment System, known as CRIS, QSIP, Committee on Uniform Securities Identification Procedures, SIC, Standard Industrial Classification System, ISIN, International Securities Identification Number, SINS, QSIP International Numbering System, LEI, Legal Entity Identifier, and ANA, Association of National Numbering Agencies. You want all the numbers associated with this here case number, all right? And you also want the temporary QSIP number that they have fixed to it when they first get started as well. They have a temporary identifier until they actually get a fixed QSIP number on it. Certified indication of the amounts secured per bond per each offense charged per IRS Form 1099 OID. All right. Now, the other thing that you could do is when you're asking for this information, you want to know the penal sum of each and every fucking charge. All right. You have a right to full disclosure, and we know this shit is banking, and we know they're doing this under maritime admiralty jurisdiction. We know this is an Article 1, Section 8 military tribunal where they're hypothecating credit into existence and trying to get you to come in and substitute yourself as the obligor or debtor. All right. So you're the only creditor in the room. Everybody else is a debtor. The expiration date and specified interest for the specified length of time of the bonds, which government body and whom or what person, i.e. special purchase entities, underwriters, corporations, companies, associations, firms, partnerships, societies, joint stock companies, individuals, and or officers secured the bonds and hold the bonds. We need to know who has them so we can come back and accept them for value. All right, accept all the charges for value. Use our exemption for post set-off and closure and recoup the funds. Any and all records and data concerning the bonds, thrift financial reports, balance sheets, okay, this is the Federal Reserve Form 2046, 2049, and 2099. In accordance with FASS Accounting Standards Codification 420 FAS 95, FAS 133, FAS 125, Securitization Accounting, RC-S/RC-B FFEIC call schedule. This right here will send the judge to the fucking roof. AO10A, AO213, AO215, AO430. All 300,000 plus GMEutility.org accounts, LEI, see attachment, that are attached to the case identification numbers and bonds and securities. If the information records and or data requested are placed, filed, secured, and or held in separate, different, and or distinct file by or under other names, numbers with identifiers other than the case cause docket number and or identification listed above, i.e. such as the auto trice number, the CRIS number, I authorize your department, agency, division, room, registry, bank, financial institution, or on deposit to open and or access files, for all the information, court records, and or data requested herein. It is further requested that the department, agency, division, room, registry, bank, financial institution, or on deposit, in response to all of the information requested, specifically inform me if and to what government body and or to whom and or what person previously described has been released and or is disclosed any of the information and or material requested herein, their name, their title, their purpose, and the need for such information and or material, the data of release, and the specific information and or material released and or disclosed, such information and the specific reference to authority, statute, or regulation governing such release and or disclosure in all things defendant so prays, we will know by this that we are the truth and we are the truth and will assure our heart before him in whatever our heart condemns us. For God is greater than our hearts and knows all things. 1 John 3, 19 through 20. Submit it and, of course, your name. Pretty simple. Always number the bottom of your pages. What else do I want to share with you? If you want to know where that list came from, it comes from right here. And it is specifically found right here. 48 Code of Federal Regulations 28 through 53. When all the seats of government were given over to the United Nations, the Code of Federal Regulation took over. All right, Code of Federal Regulation is supreme in their little private for-profit banking organization, along with the UCC. So it's 48 CFR 28 through 53. And then if you go and look at 31 CFR 357, you can they give you a diagram of how the banking system actually works, all right? So they're alleging things are criminal, when all reality they're civil. They're doing it to generate funds. They're using the statute, code, city ordinances, rules, and regulations that don't apply to you. They only apply to the things that they create, the creatures that creepeth upon the earth. Remember, the Heavenly Father gave us dominion over everything that creepeth on the earth. And the surname creepeth on the earth. Let me tell you something. The surname is a creature of the state, okay? It's a creature they created. It's a legal apparatus, okay? The Seste Kvi Trust is a legal apparatus. Where did man get the idea to create a trust? They got it from the Heavenly Father. First he created the estate, then he created the animals and the birds and the fish, and then when he saw all that was perfect, he fucked up and created man. And we are like the scourge of the earth, like a cancer that plagues this place, destroying perfection. But we were given dominion. We were supposed to be caretakers and stewards. When he gave us dominion, we then and there assumed the role of steward or fiduciary trustee. We were supposed to be fruitful and multiply and be plentiful and joyous and take care of our brothers and our sisters. And then the legal society showed up. The ones with the forked tongue, the ones who are hell-bent on deception, the offspring of Lucifer himself, if you will, all right, that are proud about their accomplishment in deceiving, lying, looting, plundering, pandering, and engaging in piracy on our land. They're very, very proud and boastful that they're behind every organization and swindling and stealing from the people, all right? So 48 CFR 28 through 53. And then you will see the list, because remember, they're registered with the DOD, the clerk of the court's registered with the DOD, so she can negotiate these bonds. And then when we get over here to administration, you're going to see, because it's a little confusing when we start talking about construction bonds and contract bonds. So you got to get deep and balls deep in this so you can see it for what it is. Right here. 28.103, performance and payment bonds for other than construction contracts. 28.1031, generally, agencies shall not require performance and payment bonds for other than construction contracts. However, performance and payment bonds may be used as permitted in 28.103-2 and 28.103-3. The contractor shall furnish all bonds before receiving a notice to proceed with the work. No bond shall be required after the contract has been awarded if it was not specifically required in the contract, except as may be determined necessary for a contract modification. 28.103.2 Performance Bond. 8. Performance bond may be required for contractors exceeding the simplified acquisition threshold when necessary to protect the government's interest. Why would they have to file this bond, ladies and gentlemen? Because they're wagering. They're wagering. They're gambling. They're betting on the fact that you don't have the acquired knowledge to stop them from fucking hypothecating your credit into existence and then making you the damn default debtor who's failed to take care and settle its obligations, all right? And they're going to set your happy ass in jail as surety while those bonds mature and a third party invests in them, and they're going to make tens of millions of dollars off of it, okay? And if they get caught, they have to ensure the government doesn't foot the bill for it or doesn't end up being liable for it. The following situations may may cause for a check of performance to be issued, right? Government property or funds are to be provided to the contractor for use in performing the contract or as partial compensation, as in retention of salvaged material, salvaged title. Admiralty maritime law deals with salvaged vessels, okay? And your all caps ens legis entity that really belongs to them, you just have cestque use of it. You are a cestui having cestque use of it. You don't carry the primary active degree of fault for that all caps ens legis entity, all right? A contractor sells assets to or merges with another concern and the government after recognizing the latter concern as the successor in interest desires assurance that it is financially capable. 3. Substantial progress payments are made before delivery and end items starts. 4. Contracts are for dismantling, demolition, or removal of improvements. B. The government may require additional performance bond protection when a contract price is increased. C. The contracting officer must determine the contractor's responsibility, see subpart 9.1, even though a bond has been or can be obtained. 28.103.2 Performance Bond. A performance bond may be required for contractors exceeding the simplified acquisition threshold when necessary to protect the government's interest. The following situation may warrant a performance bond. Government property or funds are to be provided to the contractor for use in performing the contract or as partial compensation, as in retention of salvaged material. A contractor sells assets to or merges with another concern, and the government, after recognizing the latter concern as the successor in interest, desires assurance that it is financially capable. 3. Substantial progress payments are made before delivery of end item starts. 4. Contracts are for dismantling, demolition, or removing of improvements. B. The government may require additional performance bonds protection when a contractor price is increased. The contracting officer must determine the contractor's responsibility, see subpart 9.1, even though a bond has been or can be obtained. Let's see here. We want to get to the administration section here. Annual performance bond, other types of bonds. Patent infringement bonds, advance payment bonds, patent infringement bonds. Here is the list of bonds that came from those documents. This is where this information was found, all right? SF-24 bid bond, SF-25 performance bond, SF-A payment bond, SF-25A payment bond, SF-25B continuation sheet, okay, for this. All right, this is where that information was harnessed from, and I think it's always important that if you're going to share information, you show exactly where the fuck it came from. This hyperbole and conjecture and stroke my fucking ego because I'm regurgitating and repeating what other people have said is bullshit. I can't stand people that try to teach that way. Oh, the Heavenly Father has touched my soul, and I just put this on the paper, and then they gave me a check. Okay, what exactly did you do? Where's your substantial evidence? What's the literature that you read that led you to make a conclusion and scribble some shit on paper? All right? And they can never ever fucking tell you, and it's so aggravating, because I know that people do things, and they slip through the cracks, and then 3 to 5 years later, they got men in black suits knocking on their fucking door, arresting them for some type of fraud or, fraudulent documents or whatever the case may be. So I never just take people at their word. Show me your work. Show me your work. Let me know where you got it from. All right? So this is their own writings. All right? This is all the stuff they're supposed to have. Okay? You got your surety bonds. And then, of course, the last video, I showed the equity in the statute. Let me show you where I found that. Furnishing information. Right here. 28.106-6, furnishing information. This is why I say it's better to come in the capacity of the surety, because I've read Gibson Suits and Chancery. It's a long read. It's brilliantly put together. Some of my other favorite mentors that are long dead and gone. You got Joseph Story, Pomeroy, Aristotle. And before you go off on the deep end and go, well, Aristotle, what? Philosophy is huge. And for the greater part of humanity, most law is philosophy, or the science of philosophy. It really is. It's fluid because it's forever changing due to the way that society changes over time. There was a date and time women didn't show their ankles. I mean, to see a lady's ankles, whoa, boy, oh boy, did you see something, right? Nowadays, their whole fucking hoof hangs out. There's nothing left to the imagination. It's absolutely atrocious. The surety on the bond, upon its written request, may be furnished information on the progress of the work, payments, and the estimated percentages of completions concerning the contract for which the bond was furnished. All right? Remember, all these statutes, codes, city ordinances, rules, and regulations are nothing but contracts. In maritime admiralty law, everything is about contract, and it's all presumed and assumed that you know this stuff already. All right? There are no facts and evidence. There is nothing to be challenged. There's nothing to quibble or argue about. The bottom line is, who's holding these motherfucking bonds and produce all the information required for me to be able to use my exemption to accept these charges for value? I need the charging instrument so I can accept the charges for value, but before I can do that, I need to know exactly how much penal sums are attached to each charge to make sure the taxes are paid so the United States Treasury isn't fucking cheated. Okay? I have to report to my principals. I have a couple principals I have to report to. The Treasury and the IRS. All right? And they don't like it when you start talking like that because they are engaged in tax evasion, money laundering, extortion, Clayton Act violation, Hobbs Act violation, human trafficking, the trafficking of persons, all right? The hypothecation of your credit into existence without formally having the authority to do so from the Secretary of Treasury per Title 26, 6903, per Title 26, 2032, AE 11. They're supposed to be independently bonded at the Secretary of Treasury of Puerto Rico before they even touch decedent estate property to ensure that if they cause any harm, damage, or loss to the United States Treasury or the decedent estate property, that their bond can be liquidated before they issue a summons under Title 26, 7603. Go check me on that. I believe it's 7603. It might be 7306. Before they can even issue a summons pertaining to the estate, they have to have permission from the Secretary of Treasury of Puerto Rico. All right? They have to be registered with the Foreign Registration Act, pursuant to Title 8. Once they take their oath of office, they are foreign to us. The United States is Article 1, Section 8, Clause 17 is a territorial jurisdiction that exceeds no greater than 10 square mile area. All these agents and agencies work for subsidiary corporations of a parent corporation known as the United States, which is found in Title 28, USC 3002-15A, B, and C. All right? They do not have jurisdiction on our land. They are usurping power otherwise not delegated to them, and they are sending out their agents and agency, their rogue pirates, foreign armies standing on our soil, trying to use foreign law outside of the scope of their jurisdiction to ensnare we the people into their folly and frolic so they can fleece the trust that has been created for us to protect our life, liberty, pursuit of happiness, and the enjoyment of property. And they have been extraordinarily successful, and we are the ones to blame. I don't blame a thief for taking something when I invited him over knowing damn good and well he was a thief. I'm the one to blame, all right? I had faith and belief that the thief wouldn't be a thief that day because he might actually respect somebody in this world. So, lo and behold, I invite him over, and the thief takes shit from the house. All right? Who's to blame? Who's really to blame? I am. I knew better from the get-go. All right? I had faith. I had hope, right? And at the end of the day, I'm ultimately responsible as the caretaker of the home and the home front to make sure that I don't invite the thief into the house. I carry the primary active degree of fault to make sure things don't come up missing. Well, that's our job. Where we carry the primary active degree of fault is holding these people accountable. They don't have the Title V United States Code 3331 oath of office. They don't have the Title V United States Code 3332 loyalty statement in place. They don't have the Title V 3333 statement that needs to be filed in support of their oath of office, okay? They don't have their loyalty and fealty oath. They don't have their anti-bribery statement on record. They don't have their Title IV United States Code 101 oath of office on record, all right? They have a multitude of other oaths. But if you have multiple oaths, who exactly and where exactly does your loyalty lie? Bible's very clear. You can't serve two masters. You'll love one and loathe the other. All right? And so these are all the fronts and different aspects that I hit them on. I hit them on the Form 56. I hit them on the 13909, 3949A, 4506A, the 211 form. We hit them on the IRS identity theft form. What else did we hit them with? The IRS Form 990 for their principal. We hit them with the W9, W7, W8. We need their EIN, TIN, or ITIN. We hit them at the FinCEN for unregistered securities, unauthorized unregistered securities. We hit them there as well. You can also use the Fair Credit Reporting Bureau because they're debt collectors, and you can hit them there as well for identity theft and not having the consent to contact and communicate with you or use the information, the private intellectual property. FinCEN the SEC under the Code of Federal Regulations gives a really nice layout of what constitutes identity. And therefore, if they're in constructive possession of any of that information, including retina scans, vocal recordings, biometrics, your email, your phone number, your address, there's a number of other things in the Code of Federal Regulations where they're articulating what actual identity is. And so if they're in constructive possession of that without your express written consent, guess what? That's identity theft. All right? They're engaged in RICO, racketeering, organized crime syndicate. Again, they're using maritime admiralty on our land, and they're using rogue agents and agency to drag you into their foreign jurisdiction and dry dock without fully informing you of the nature and cause of what's actually transpiring. All right? So anyway, I wanted to show you where this information came from. That way you understand it's not just hocus pocus and gobbledygook and bullshit. Obviously, the Federal Reserve Form 2024, 2025, and 2099 is not on here. That's information from a different location, but you can just go and look up Federal Reserve Form 2024, 2025, and 2099. That will better clarify exactly what's going on. They're required to fill out all this documentation, all right? because it's all about banking. It's all about keeping a ledger. The other thing that you can do is you can report these agencies to the Federal Reserve Board of Governors. They also have identity theft forms, and you can report them as well. All right, they're financial institutions, and they are governed by the Federal Reserve Board of Governors. They are governed by the IMF, the International Monetary Fund. They are governed by the IRS. They are governed by the Federal Code of Regulations. They are governed under Title 12 because they're banks. They're also governed underneath what's the other one? Statutes at large, okay? Under the 73rd Congress, First Session, Volume 77, Part 1, 40 Statute at Large, 411, Section 7E. Ladies and gentlemen, I can't stress that out enough. 40 Statute at Large, 411, Section 7E. 40 Statute at Large, 411, Section 7E. If I've said it one time, I've said it 1,000 times, and guess what? I'm going to say it one more time. 40 Statute at Large, 411, Section 7E. It's so powerful. And after really reading it and digesting it and comprehending the power of that paragraph is phenomenal. All right. And then you have 48 Statute at Large, 112. They can't demand anything of you in the form of currency or money, because it would violate public policy. It would violate Title 31 USC. It would violate Article 1, Section 10. Nothing shall be tendered for payment of a debt other than gold and silver coin issued by the United States Mint under the Coinage Act. Okay? So when they're specifically demanding a performance of you and you ask what specie, and they can't provide what specie, not species, specie, singular, because there is only one specie. Gold or silver coin, right there. That's it. With intrinsic value, minted by the United States Mint. That is the only thing. You're saying there's a debt? Well, the only way a debt can be paid is Article 1, Section 10, right? But again, we're not here to argue and dispute. We're here to just come in and agree and go ahead and satisfy the charges while using our exemption to go ahead and do a post-settlement and closure. But we need a full accounting. We need to be fully availed. If we're going to come in as creditors with our exemption, which is 40 Statute at Large 411 Section 7E, ladies and gentlemen, by the way, you cannot be put in jail. Any rule, regulation, proclamation, or order made by the President of the United States is a full acquittance and discharge. Full acquittance and discharge, and no man shall be held in any court for any reason that is done or omitted and executed under any rule, regulation, order, or proclamation made by the President of the United States after March 4th, 1933, ladies and gentlemen. Huge. 40 Statute at Large, 411, Section 7E. If you want to understand how powerful it is, I would implore and encourage you to go look at Title 1, United States Code 112 and 113. It tells you clearly the law that cannot be challenged. It is an irrebuttable fact in their system that the statutes at large are legal evidence of the law from the highest to the lowest courts. Period. End of story. And 40 Statute at Large 411 Section 7E has not changed since March 4th, 1933, ladies and gentlemen. They backdated it pro rata because they wanted to catch Proclamation 2039 and Proclamation 2040 the following year, but they needed to catch Proclamation 2039, so they backdated it to March 4th. They actually made the decision, I believe it was on March 6th or March 9th, and they backdated to March 6th through March 9th, and they backdated it back to March 4th. All right? So there's the power in that. Understand that you're not the fucking name. Understand that what they're creating is an escrow account and bonds. You have the authority to create all of these documents, and you just need some information from them. All right. 9091 is release a lien and release a surety. Right there. Everything they do in maritime admiralty is all predicated on presumptions and assumptions. Look at this. 28.106, consent of the surety. It's the same in every section. You just got to go read it. All right. And additional bond is obtained from other than the original surety. No additional bond is required. The modification is for New York beyond the scope of the original contract, or the modification does not change the contract scope, but changes the contract price upward or downward by more than 25% or $50,000, so on and so forth. And you just go through there and read this. And again, you're wondering where I'm reading this from. It's actually a private document that was put together. And right here, it says very clearly that 48 CFR 28 through 53. All right. And so when you get down to the bottom of this, you see it starts to get into the 53s. And again, the gentleman that put this together is not going to hold your fucking hand and tell you how it's done. He needs you to see it for yourself. He's just giving you the place to go read it so you can understand it fully. All right. And it goes into what all this is. Remember the solicitation, offer, and award. All right. The SF 1442 is prescribed for using in soliciting, offer, and awarding contracts accepted to exceeded the simplified acquisition threshold for construction, alteration, or repair, or dismantling, demolition, or removal, or improvements, and may be used for contracts within the simplified acquisition threshold as specified in 36.701B. All right, acquisition. What is a 1099A? It's an abandonment or an acquisition. What does the government do all the time? They acquisition things. All right, abstract of offers. Construction, so on and so forth. We're in the 53s again. Novation and change of name agreements. SF30, amendment of solicitation modification of contract. SF30 prescribed in 53.243 shall be used in connection with novation and change of name agreements as specified in 42.1203H. All right. If you don't know what a novation is, you need to go look at it. Be similar to something like accord and satisfaction. Other people were asking me, can't you do an accord and satisfaction instead of a post-settlement and closure? Well, accord and satisfaction is a new contract, a new deal. I don't know if you want to be making deals with the devil, but that be your choice, not mine. So the choice is left to you. But, I'd much rather do post-settlement and closure utilizing my exemption and accepting all the charges for value. And the reason that you're doing it is because the charges don't matter. What the charges actually say don't matter because everything that they're doing is for generating revenue. There is no injured party. You cannot cause harm, damage, and loss to the state. It's a figment of your fucking imagination. Just like you can't kick Tinkerbell in the balls, and it's not because Tinkerbell is the personification of a female. It's because Tinkerbell doesn't even fucking exist. All right. So I hope this helps you guys out. Love you lots. Talk to you soon.